Oh, that's right. Sorry. I forgot I have to click into I have to join the group. Last week, right? I'm gonna do this.
You have to join and turn off the sound. You have to join.
Oh,
You don't
no,
have
I don't. I'm sorry.
You're here.
I just feel a little bit like too many things going on today. Okay, yes. It was another meeting that I was at. Okay, great. I didn't think that happened before. Okay, so can we start? Yeah.
Yes, sure.
All right. Good morning. It's April 15th. This is a meeting of the House Sexual Harassment Prevention Panel. And in the room here, we have Arlene Donovan, the Human Resources person for the legislature, Jen Carby, Chief Counsel of Legislative Council, Senator Ruth Hardy, the chair of the Senate Sexual Harassment Prevention Panel, and we have vice chair of this committee, Representative Mike Moricky. We have Representative Marty Seltis, Representative Patty McCoy, and myself, Representative Molly Burke, chair of the committee. Representative Tiffany Bloomley is not here today. So we can continue with what we are doing, is looking at our procedures, our new procedures. So
That's right.
if you want to.
Yeah, so Jennifer Carby, Office of Legislative Counsel. Can you remind me where you think you've left off? Because Arlene and I have two different thoughts. About where you,
Sorry.
what you have been, how far you've been through.
Wait a minute. Gotta get to this. So we are from our committee page. And there was
And share.
there were documents on April 1st
Yep,
from Damien.
yep, and I will
One was
share
the
that.
procedures and one was the policy.
Right, so I think we're on the
We were looking at
procedures.
Procedures, yeah.
Right.
Rule 6, I left early, so I don't know how far you got after that. Marty, do you remember? Because I have one.
Well, if you think you're,
Talking
if
about
you think you've
numbers.
looked at Rule 6, then you're probably where Arlene thinks you are, which somehow, maybe I was multitasking, which would lead you to just after conflict of interest. Page numbers on here, but that is page, what?
Rule 11.
Yes, just before Rule 12. So that is on page 6 of the document. Does that sound right to everyone? No, there aren't page numbers. I'm just, if you happen to be looking at the document online, you can see on the PDF, it'll show you 6 of 8. Up on the top
So
left.
Rule 12, you mean, pairings?
I'm gonna keep it small.
Yeah, okay.
I know we talked about the possibility of legal retaining, a retainer and that sort of stuff, as I went back and talked to my appropriations colleagues about that part. And I guess I didn't. That's important.
Yeah.
Okay, well, let's pick up where Arlene has notes that you ended at the last one. So that's right after Rule 11. So this would take us to Rule 12 and when a hearing is held. So it says that the panel shall hold a hearing after charges are drafted unless the respondent and complainant jointly agree to waive the hearing pursuant to Rule 10D5, which is right up to actually at the top of that same page. They can jointly agree to waive the hearing. And then it says that the panel shall hold a hearing for an appeal filed pursuant to Rule 21, which we haven't gotten to yet, within a reasonable period of time after the hearing is requested. Questions or comments on that? Okay. Rule 13 is on the conduct of hearings and the standard of proof. So first, the chair of the panel will preside at any hearing. It gives the panel the legal counsel and assistance of, and then I think this bracketed issue that we're still discussing about Office of Legislative Counsel or outside counsel. And the panel would have the administrative assistance of the Office of Legislative Operations. So similar to other committees and panels. It allows the panel to contract with the investigator who did the investigation or another person to prosecute the charges. And that person would present the investigator's report to the panel, and they may present evidence, call and question witnesses, and present arguments to the panel. It specifies that the panel is not bound by the Vermont Rules of Evidence. So you're not a court, you're not bound by the Vermont Rules of Evidence, and you may admit any evidence that you consider to be reliable, material, and relevant. And the chair would make evidentiary rulings about whether something could be admitted or not that may be overruled by a majority of the panel present at the hearing. The burden of proof remains the same as under your current policy, and that's clear and convincing evidence.
Jen?
Yep.
So on the spectrum of burden of proof.
Yep.
Is that right in the middle?
Yes.
Okay.
It is more than a preponderance of the evidence, but less than beyond a reasonable doubt.
Yeah, that's always helpful to know.
Yes. And this tells you a little bit more about that. The standard indicates that the alleged violation is highly probable or reasonably certain, but again, not the beyond a reasonable doubt criminal law standard. Evidence is clear if it is certain, unambiguous, and plain to the understanding. It is convincing if it is reasonable and persuasive enough to cause the panel to believe it. And finally, under this section, the decision of the panel shall not be based solely on hearsay evidence. So not just based on what other people are reporting. And I do also want to note that Katie McLean has joined us. So Katie, if you have anything to add, please feel free to jump in.
Great, thank you. I'll only be here briefly. I have to be in committee at 9.
I have a question.
Sure.
Just, so if we were having this, the panel would be there, the counsel would be there, the investigator would be there, evidence would be presented, and then the panel would take a vote on, how would that, I'm just trying to.
You're talking specifically about the evidentiary rulings or
During a
getting-
hearing, yeah.
or getting to the decision?
Yeah, getting to the decision.
We're still getting there. This is just about
Okay.
kind of some of the conduct
Alright,
during the
okay.
hearing.
So are we taking this rule by rule? So if we have a question on this rule, we should bring it up now?
I think so.
As opposed to waiting until the end or something. No, I would prefer to go through it as we go on.
So did we decide, I should preface that by saying, did we decide last week that we were going to have a retainer for an attorney who his or her office may also have an investigative unit, or is that what have we talked about that at all?
I remember talking about it, but I don't
I
remember
think we
that.
made a decision.
Because this rule 13B1, it's like the Office of Legislative Counsel /
Right.
outside counsel.
Right.
Right, that's
Yeah.
the decision that I think is still somewhat being determined, I think. And your legislative counsel who worked on this with you, have been meeting to discuss as well what we think is appropriate.
Well, I know that you may have a conflict of interest as legislative counsel if it's between two members, so.
Right. And so that's where it may depend on the particulars of.
And maybe that's how we word it, depending on, conflicts arising between legislative counsel, outside counsel will be, accused or something. I don't know, because if it's just a member and it's like a lobbyist who comes in, they're within this, right? Because
They are as complainants, right?
Right, so.
Yeah, that's certainly an interesting approach to address. Are we going
Julia
to?
has
I can
something.
just give a quick update where we left off last. I think what we said was that human resources would go and actually seek some options outside, get some, see what our options were. And we were particularly looking for a firm or a group of attorneys who could handle not only harassment, sexual harassment investigations if we wanted or needed one, but also someone who could maybe provide some outside employment issue advice if my office needed that, and maybe someone who could also do a discrimination investigation. And we also talked about mediation as well. So I can tell you that our office has started that process. We've gotten several recommendations from Ledge Council, and we actually started making those calls yesterday. So we're just
They would
looking
be
at
just
the
on
options.
retainer, and then if we wanted them,
Yes.
we would be able to call on them, and we wouldn't have to go through the process of looking for somebody at the time,
Mhm.
which I think is a great idea,
But
to have the retainer.
Yeah, but I am in,
wording of this, I think, because if it's,
oh, I don't think, we won't just leave it in brackets like that. I think we'll say,
and I don't know if we're gonna try to come up with language now or think about it and come back.
I'd like to think about it and come back, but I
Okay.
mean, I
You
do
know what
think
I'm
your
saying.
suggestion is an interesting way to potentially set it up.
That you-
Because you're exactly right that our concern is about conflicts with
Okay.
our relationships with you at all as clients.
Thank you.
But that's a new potential approach, and I like it, but I want to talk to my colleagues.
Okay, great, thank you.
But yes, I think once this is moving toward a final version, we will need to be
Okay.
not having things in brackets like that. That's really
Okay.
more as a conversation.
Thank you.
Anything else on Rule 13 before we move on to Rule 14?
So I just, we're talking about the hearing. And maybe this is during the hearing. I don't know if it's the outcome of the hearing, and maybe you're getting to this. It will be, okay, I'll wait. It's coming.
Okay.
I didn't wait.
Well, that's okay. I mean, you're not expected to know what is and
Just
isn't.
trying to sort of visualize this situation.
Right, so the part where there would be a vote would just be if the chair made an evidentiary ruling that the panel did not agree with, they could vote to overrule that.
So I could say, I think we should not include this evidence.
Right,
And everybody else will
else says
say,
yes.
we disagree, and we're gonna overrule it.
Right.
Okay.
Pressure, Molly.
Except that the final point, I think is important, that we can't base everything just on hearsay.
Right.
Right.
Yes, exactly.
Okay, Rule 14 is rights of the parties, and the respondent are individual of their choosing present to provide support at the hearing. They may hire their own counsel at their own expense. This is, again, similar to language that is in your existing policy. And counsel and anyone else who is present to provide support shall not be a potential witness at the hearing. The complainant and respondent may testify, and the complainant and respondent or their attorneys may present evidence, call and question witnesses, and present arguments to the panel. Rule 15 is setting of the hearing. The hearing shall be closed to the public unless the respondent and complainant both agree that it should be open to the public.
Is there any reason it should be open to the public?
I think I think we were not coming up with one, but also wanted to allow, if both parties felt that it should be somehow done publicly, that they could allow for that. But I would not expect that to be exercised much. I don't know from your experience in other settings if that's
No,
seems likely.
not typical.
And I think close to, finding a private space is a challenge these days too.
Right, but I mean, this could be a
Right,
private
that's true.
space
Yeah.
without
Yeah.
being live streamed. All right, so then Rule 16 is outcome of the hearing, which I think is where Representative Burke was going. So if the panel finds that there is not clear and convincing evidence that a violation of the policy occurred, then you dismiss the complaint. And in that case, you would meet with the respondent and complainant either separately or together and summarize the basis for your determination. The panel would provide the respondent and complainant a brief letter summarizing the panel's action, but with no names or other identifying information. And then the chair would notify the speaker that the complaint has been dismissed, but not the identity of either the complainant or the regulated individual. And then subsection B starts, if the panel finds there is clear and convincing evidence that a violation of the policy occurred, then you would recommend corrective action. And we'll look at that in the next rule. After corrective action has been recommended, the chair of the panel will meet with the speaker and inform the speaker of the nature of the complaint and the identities of the complainant and the regulated individual, and summarize the basis. Oh, I'm forgetting to scroll along here. For the panel's determination and the recommended corrective action. The meeting is not necessary if the speaker has previously received this information.
But I think there's the question here of how that decision is made, not the corrective action, but whether it's a legitimate or not a legitimate complaint.
Well, that is up to the panel to determine whether you find that the alleged violation occurred based on clear and convincing evidence.
So is that just going to be a discussion around the table and, oh, we all agree this is not a valid complaint? But Mike thinks it is. I mean, are we going to vote or are we just going to have a convince?
That is a very good point. There's nothing in here that specifies.
And the
How to
other
make
specification, and that is, that I'm assuming this will be behind, like, no, it's not open to the public.
Right, no, but that's a good point too, is that we should specify that the deliberations
Right.
are private.
Yes, because I don't want,
Are not
I mean, if
public.
we're gonna be
No, that's-
candidly discussing,
Yes.
I don't want.
Yeah.
So I think any other deliberative session or whatever you want to call it, that we're gonna go into and just be free to discuss and, you know, freely discuss. If Mike disagrees or if Marty disagrees with me, we can have an exchange without
Right.
Yes.
the world.
And the
Yes.
question is, would we like to have consensus?
But it would, I guess. Yeah, that's how because that other one went closed to the public unless the respondent and complainant both agree. I don't know.
Right, but again, that would be like if the court, in a court proceeding is open to the public, they can see the presentation of evidence and the questioning of witnesses, but then the jury still goes back in private and
Yeah.
deliberates, or the judge goes in the chamber, so I think that's
Okay,
Still-
that's fine.
still makes sense.
Right, but I think we want to specify that the panel's discussion is in a
It's going to
deliberative
be
session,
in deliberate. session.
like a zoning board.
Right.
Where you present all the evidence and people
Going
can.
to
Yeah, and then
executive
we'll
session.
take it
Right,
into-
and then we'll give you a response a week from now because we can sit down and we're gonna have our own discussion about it.
Correct, yes.
But then again, point how that discussion, or how that decision is
Right.
reached, whether we all have to agree on it or whether it's a vote of 5-2 or 3-2 or whatever.
What do you recommend?
I mean, obviously your options are, a majority or something more than a majority. I think I would hesitate to use something other than either a majority or some specific threshold. Like if you go with unanimous, that's a pretty high bar and you risk a lot of instances in which there's sort of the equivalent of a mistrial. And then what do? Do you redo the whole process? It seems like you need to come to the panel needs to come to some kind of a decision.
Do you know what the ethics panel or the diversity panel do?
No, but those are good questions. Let me find out, because I think
Okay.
at least with the ethics panel, I think they may have had more occasion to,
Probably not more than.
yeah.
And I think you're right that we wouldn't want to specify unanimous because,
No,
Just
I
to-
don't think so.
but I think we also wouldn't want to have a 3-2 vote either.
Yeah, correct. So
You know. I don't know.
All right, these are good things for your Ledge Council and HR to talk about. So thank you for flagging those. Recognizing we have not, come to closure on those, are you ready to move on to look at the rest?
Yeah.
Okay. So then we have recommendation of corrective action. After determining that a violation of the policy occurred in Rule 16, the panel would make a recommendation of corrective action to the appropriate entity as set forth in the rule. If the regulated individual is a representative, corrective action may include counseling or training, removal from a committee or committee leadership, censure or expulsion from the House. And the panel would recommend corrective action pursuant to House rules. So that's one option. Another is that the panel would recommend the appropriate action to the Rules Committee. And then I think this may be how Damien was showing that this would actually play out. The Rules Committee would determine the appropriate action and propose a resolution.
So another committee would get involved with,
Well, as far as a lot of the actions that would be done, I think something like counseling or training could be done just based on the panel. But removal from a committee or committee leadership, I think would be a decision of the speaker. And then censure or expulsion would likely, well, expulsion would have to come from the House and censure would
There
as
would
well.
have to be a vote.
Right, there would need to, right. But that would be something that the rule, typically, I think the Rules Committee would be involved with.
Boy, we never get to that point.
yeah. But just imagine if this panel comes up with a determination and then says to the Rules Committee, we think this person should be X, Y, or Z should happen to this person. Would the Rules Committee then want to sort of litigate
Yes,
the whole
it's an
thing?
interesting question.
And that could get super complicated.
Let me get some clarity from the clerk about what requires the Rules Committee involvement. Because it is an interesting question.
Rules may have to, for censure or whatever, have some kind of resolution drafted.
Mhm.
But then it makes me think, could this panel have a resolution drafted?
Well, I think, didn't we just?
We
handle
just
one
draft-
with
we
the
just
ethics?
presented a
Right.
resolution.
Just did something for ethics that they wanted subpoena power.
Right,
It had to come through House rules. It just did a drive-by, and then it went to the floor.
Yeah.
was it presented by,
John Gannon, the chair.
I mean, so, I can't remember if it was his name on
On
it.
a House, but John Gannon came to House rules.
Right,
They wanted, ethics panel wanted subpoena, and it wasn't in rules, so
mhm.
they had a rule drafted, but I think we
I
just,
think that was to amend the House rule.
yes.
And so this may be different because it's
We
not,
don't have
wouldn't be
one.
changing the House rules. It would be recommending an action. And so I'd like to check with the clerk.
I would like to see the panel have the authority, the ability, the
Right.
responsibility to suggest the corrective action. Censure training, and even if the corrective action is censure or expulsion, I would think this panel should make that recommendation.
To the Rules Committee.
Well, either to the Rules Committee or is it to the if you're talking about censure or expulsion, does that go to
Well,
the speaker?
I think that would, I think that would be in the form of a resolution that would be in the House. The question is, could this panel author that resolution? Or do you need some involvement from the Rules
Didn't
Committee?
we just, or maybe it was an amendment, didn't we just, I guess it was an amendment just recently for the ability to meet remotely?
Right, but that was amending the House rules, and this would not be amending the House rules. This would be taking an action.
Okay.
So let me talk to Betsy Ann about what that needs to look like.
Okay.
Is there nothing currently in House rules regarding censure or expulsion?
I think there is.
Or that they
And I
have the
think-
authority to?
I think the House Rules Committee meets, and then it goes to the body for censure expulsion. I mean, the House Rules Committee can't vote to, it has to be the whole
The whole
body.
body, okay.
Yeah.
Okay. But I think the initial recommendation could come from this panel.
Oh, I think
So the
it has to.
recommendation would come from this panel. The question is, do you need to, and I think it's a valid question, do you need to involve another committee, or do you, in an official way? Meaning, does the Rules Committee get the chance to say, no, we don't think that should move forward to the whole House? Or do you, as the panel, get to bring it to the whole House and the whole House decides?
I just think about the person, the people involved and then having to do it all again because maybe, like, you know, they're like,
On the other
the
hand,
other committee is saying, well, I don't think that, I don't believe this or whatever, and having to relitigate it multiple times.
well, they wouldn't necessarily
I
have
don't-
the
I don't-
authority.
Yeah,
to stop it.
right, they might not have the authority, but they could say, well, I don't really, you know, based on hearsay, they could think a different thing.
Yeah.
And.
Well, otherwise, we would just have to bring a resolution, bypass the rules committee, and bring a resolution to the House, but I would feel very strange to not involve the rules committee in terms of at least letting them know what's happening, you know.
Well, and I think if it goes directly to the House, we're not gonna wanna relitigate this all over in front of the whole House either.
Correct.
I think all you're gonna have is say,
Yeah.
the panel has found such and
Yes.
such, and recommended this,
And
and
they
the
can-
rules committee endorsed their
There
recommendation.
can be an appeal.
Yeah, I think there is an appeal. Is there an appeal coming up?
Yeah, there's an
Yes,
appeal
there's an appeal coming up. That's true. So I think you'd also want to make sure you weren't doing something after, or, you know, we weren't doing something until after you knew whether the one party or the other was going to appeal. So these are great questions and exactly why we're going through this. I think it would be good also to clarify in here what the panel could do itself and what it might need to, what might require somebody else taking action, like the speaker that involved committee membership.
I have to go.
Thanks for coming, Ruth.
Yeah, I think the Senate panel is gonna start to look at this just because we're running out of time.
Yeah.
And I want to make sure we all have time to pass it. So we'll try to stay in touch about it. Yeah. Good luck.
Thanks, see ya.
Okay, so that was if the regulated individual was representative, and I think that's definitely brought up a number of questions.
Mhm.
Next is if the regulated individual is the House clerk, corrective action may include counseling or training, censure, or removal. And in this case, I think it's clearer. The panel will recommend appropriate corrective action to the Rules Committee. And the Rules Committee would determine the appropriate action and may propose a resolution for House consideration imposing that action. So I think because the House clerk is appointed by the full body, the full House, that it's sort of the Rules Committee that is oversees that position. And then number 3 is if the regulated individual is an employee of the Speaker or House clerk, then recommended corrective action may include counseling or training, reprimand, loss of pay or vacation days, demotion, or termination. And in this case, the panel would meet with the Speaker or House clerk, whoever is the supervisor, and present its findings and recommendation for corrective action, and the Speaker or House clerk, as applicable, would impose the appropriate corrective action.
And they may perhaps do something less than what's recommended. Suppose.
It seems like this gives some, I mean, this is more in the traditional HR sphere, it gives more authority to the supervisor
Supervisor to,
to impose appropriate action. I think it's what they determine to be appropriate corrective action.
among the things that have been suggested.
Well, it may include, so it could be other things. But I think it would seem unlikely that after a finding of this panel that something has occurred, that there would be
So
something would be
we're still
appropriate.
talking House clerk here. I
In this case, number 3, we're talking the employee of the Speaker or the clerk.
Okay, well, I'm still trying to figure out House clerk. As we've said, the panel is going to recommend appropriate action to the Rules Committee. Then it says the Rules Committee shall determine the appropriate action, which means they haven't heard everything that we've heard. We've already done the recommendation. And we, like Marty said, they're gonna rehash the whole thing.
Well, I think in this case, in both 2 and 3, well, in number 2, I think this panel doesn't have supervisory authority over the clerk.
Okay.
I think it's the rules committee that does, although I'll confirm that with Betsy Ann. And so that's where the rules committee would be taking the action based on the recommendation from the panel.
If the rules committee has questions and starts bringing up and they're deliberating, I think that has to be a deliberative session then for house rules, because we may,
Yes, and I think that can be, because it's I mean, I think under the, to the extent there are any rules on executive session in the House, but to discuss personnel action
correct,
is a reason for executive
Okay.
session.
all right.
But let me,
Maybe kind of stick that in somehow, I don't know.
Yeah, you say, make a note here, maybe that the rules panel shall meet in executive session to determine the appropriate action. Okay. And then that last one on the page was the regulated individual is the employee of the speaker or the House clerk, and that's where the speaker or the House clerk is then acting in their supervisory capacity to determine the appropriate corrective action.
Correct.
I think that's a clearer kind of employee-employer relationships than members of the House, certainly.
So I'm thinking outside of the House, because I'm assuming the House clerk staff and the speaker's staff are state employees and follow state employee guidelines. Or do they?
Well, I don't know what you mean by state employee guideline. I mean, we're a different
Well,
branch, so we have a lot of stuff that doesn't, this is why we have Arlene here
That's
to
why I'm
help us create.
Arlene, like, is there some model that state employees, if this happens to a state employee outside of the House? Is this kind of follow the,
So I would have to check with them and see how they would handle these types of matters, but I think, you know, from my perspective, with the staff of the speaker or the House clerk, that appears to me to be more of a typical employee supervisory relationship. And in those types of situations, typically, you know, depending on what the recommendation is, it would go to that supervisor, there'd be a discussion about it, and the supervisor would ultimately make the decision that they feel is best in those circumstances after they've, you know, gathered all of the information and had all of the information. But it would be typically with advisor counsel from HR, a panel such as this, legal counsel.
say Melissa from the clerk staff is somehow, you know, the person in question that we're responding, the defendant, I guess. So this bypasses Betsy Ann.
No, because she is, so it's the clerk who would be imposing appropriate corrective action. So the recommendation would come from this panel to Betsy Ann as
Which I
supervisor.
mean, the panel is, but there is no panel for any other state employee, or is there? Is it HR? I mean, who is it? Just the
Oh,
supervisor?
if this kind of thing happens in the executive branch, what is the process there?
Yes.
I think that may go through the Department of Human Resources kind of investigation.
That's a
Yeah,
good
and we
question.
also have
They're not union employees,
Yeah, okay.
the people in the clerk's office, or are they?
Our entire branch is exempt from classified service, so nobody is
Part of the
union.
BSEA.
Okay.
Sorry, if that was the,
That's what it's like.
thank you for
Okay.
that clarification, yeah.
Okay.
So we sort of have to make our own process.
Say, well, these people don't have to go through a panel and I have.
Oh, I
to go
see.
through a
Yeah.
panel. Okay. And I am
We make
fine.
our own rules.
Which means.
We make the laws and we make
Right,
The rules
we
too.
make the rules.
And hopefully we stay consistent. Okay.
All right, so then we're almost done, so I think we're gonna finish this today. Public statement. After imposing certain corrective actions, the panel chair or speaker, as appropriate, would issue a public statement, including the nature of the complaint, the identity of the regulated individual, and a summary of the basis for the panel's determination and for the corrective action. Summary of the basis. Okay. So if the regulated individual is a representative, then there would be a public statement made if they were removed from a committee or committee leadership, censured, or expelled from the House. That's all fairly public actions. If the regulated individual is the House clerk, there would be a public statement if she was censured or removed. And if the regulated individual is an employee of the speaker or the clerk, there would be a public statement if there was demotion or termination.
So what if the recommendation of the panel is counseling or training? Is that going to be a public statement? No. Okay. Just these particular.
Just the ones that are sort of public facing, that are noticeable, I think, noticeable public.
Okay.
To the public that something has happened.
That's all we're recommending. I don't think a public statement has to
No.
be made that Patty McCoy has to go through training for, okay.
And a
Agree.
public statement, maybe this gets down to the
I mean,
confidentiality,
counseling and training, yeah.
but I could see, if you're gonna make a public statement and put out the name of the person, the regulated individual, I mean, obviously, you're not gonna put out the name of the complainant,
Right.
but, you know, it could, I guess it would have to be worded in a way that would not reveal anything.
Right, I think it would probably be fairly high level. I mean, the nature of the complaint may have been, there were complaints that the person used, you know,
Made inappropriate,
right, made repeated inappropriate comments of a sexual nature, and
didn't stop.
the panel determined that based on, you know, evidence from a number of people in a review of the committee recordings or something, and determined that removal from the committee leadership position was the appropriate corrective action. Something to that effect. All right, time periods. It's fairly general. The panel shall conclude any investigation and hearing and recommend any corrective action as soon as reasonably possible. So try to move quickly, but recognizing that there are a lot of circumstances that will be beyond your control.
And do something.
And I mean, don't want to move too quickly or box yourself into a time period that you can't meet because of extenuating circumstances or availability of witnesses or something. Then we get to confidentiality. So in order to encourage people who believe they have experienced sexual harassment attributable to a regulated individual to feel comfortable contacting members of the panel and pursuing a formal panel process, members of the panel staff, and any attorney, individual, or entity the panel has contracted with shall keep confidential any information obtained and all records produced or acquired in accordance with the policy and these rules, except to the extent necessary to carry out an investigation of an alleged violation of the policy or as otherwise set forth in these rules. So for example, it would be difficult to interview witnesses if you couldn't say, you know, were you in the room when this person said something to this person?
Should we add facilitators in there? Are those the three people, or like if somebody comes to a facilitator and the facilitator now has information that they're,
I think the facilitator may only be referenced in the policy itself, and I think it does talk about confidentiality there.
okay,
So I think that falls outside of the rules of procedure for the panel. Let's make sure that there is,
The reason for having a
yes, confidential
facilitator
basis.
is just to have people outside of the panel, like to find somebody who somebody might feel more comfortable talking to. Is that the purpose?
Yes, and I think, you know, sometimes in many cases, formally or informally contacting the panel creates some sort of process or at least obligation on the panel to take corrective action. If somebody really just wants to either talk about what happened with someone and find out what their options are, or just kind of find somebody to vent to, but doesn't necessarily want to create a process or has real concerns about anything being done, a facilitator is someone they can approach to start that conversation without creating a duty.
And is the facilitator obligated to notify the panel?
Nope.
Or no?
No, that's actually a big part of the
Okay.
purpose.
So, and I think that needs to be made clear.
Yeah, so I think, I don't,
So that-
are they in here, the
They
facility?
are, they're on the back page and under other resources, and maybe we want to,
So maybe, because you have
Run it
members of
differently.
the panels, legislative supervisors in the Office of Legislative Human Services shall keep confidential any information reported to them. Maybe we say facilitators as well, if we're specifically calling them out in policy. And policy.
I think if it would make people feel more comfortable, I don't think there's a problem adding that.
Yeah, I just,
And I think it should also be made clear, and I don't have it in front of me, that the facilitators are an option for someone who is having a problem, that, I don't know if it's straight out there, but this would be in the policy, right?
Right, so it's the policy that addresses the facilitators, and it says that the panel can appoint up to 3 representatives
Right.
to serve as these facilitators to provide information about this policy to other members on a confidential basis without initiating either the informal or formal panel processes, and that a person may communicate confidentially with the facilitator at any time regarding the person's options for resolution.
I think that covers it.
Yeah.
I think that description.
And I think
Yeah.
in the training, I think, that it happens, I think it could also be emphasized that,
Okay.
these people are also resources if you don't want to.
Okay.
Okay.
All right, and then in subsection B of Rule 20, all records produced or acquired in accordance with the policy and these rules are not subject to the Public Records Act. Rule 21 is appeals. This allows a complainant or respondent to appeal the panel's final decision resolving a formal complaint by submitting a written statement to the chair, setting forth a concise statement of the reasons the individual believes the panel's decision was an error. And that statement may include a request that a hearing be held on the appeal or the hearing section. The only thing I might suggest here is some sort of a time frame.
yeah, I don't know what Rule 12 says. Is there?
Rule 12 is Rule 12 is just the panel shall hold a hearing after charges are drafted, and the panel shall hold a hearing for an appeal within a reasonable period of time after the hearing is requested.
I mean, I don't know what that is.
Specify a reasonable period of time.
Well, I think you at least want to have, you may want to have a set period of time
Yes.
when the appeal has to be filed, because otherwise you may move forward with
We
corrective
don't want it to
action.
happen in 3 years.
Exactly.
Right. Well, we also don't want to have corrective action publicly when this person's going to appeal. it.
Exactly.
I don't know what's a good time, 15 days,
Yeah, something like that, maybe.
30 days, I don't know, 15 days.
I think if you've got something, 15 days seems like it should be a sufficient amount of time for somebody to decide whether they plan to
I don't like your decision.
to appeal. I think you don't, I wouldn't want to see too much time between when you have decided something needs to be done and then they're just hanging out over there
Okay, sure.
without the corrective action. So,
All right.
say within, and then finally, maintenance of records. The Office of Legislative Counsel shall maintain all records associated with complaints received or proceedings conducted by the panel.
Okay. Good to know, Patty, right?
Sorry, all,
Good to know, right? Yes. All right.
So the appeal is back to the same thing, right?
appeal is still within, right, appeal is,
So there's not an option to go to the Human Services Board or somewhere else.
no, there is not an option. I'm not sure where someone would take an appeal beyond the panel, other than perhaps to plead their case to the speaker or somebody to say, you know, this isn't
Thank you.
And that may affect the corrective action that is taken, but,
What about like the Human Rights Commission and all that? You would have to initiate your complaint there, is that? Because that's listed as another option.
it is listed as another option, but it's an option through the legal route. This is really, I mean, only the House can take corrective action against the House. You know, so
Okay,
you stand in
okay,
judgment of
yeah,
your
I
own
hear.
members.
Okay.
So somebody's appeal to the Human Rights Commission wouldn't have legal bearing on whether the House could expel the member.
Okay, I'm clear, thanks.
But what's that appeal gonna do? I mean,
Well, if they
person's
believe,
gonna come back and say, your decision was an error. And we all sit here and say, well, we looked at this very carefully before, and this is what we think. You know,
Well,
unless
they
they
can
have new information.
they can request a hearing to be held, and they may have new information, or they may set something out in their written statement explaining why they believe it was an error, and if the panel has reason to think, oh gosh, maybe we got it wrong,
Maybe we forgot something.
you may want to
Yeah.
reopen it. I can say, having been involved in other situations, sometimes what somebody thought was very clear when they were presenting information can be misconstrued on the other side. And without an appeal, there isn't really a way to say, hey, wait a minute, I think you made a mistake.
Okay.
All right, so I guess when we meet next,
You'll have a much cleaner copy.
and
you know, much
some of the
updated.
questions will be answered, and
Right.
we can make decisions on whatever we need to make a
So we're
decision.
gonna-
And then
Just looking at a timeline, if we approve next week, then we can take it to the full house. Present it. Or is this,
Yeah, does this need to be,
We'll have to remember how you take this.
right, I
Make
don't
sure.
remember whether this policy needs to be.
I don't know if we need to approve it, just,
Well, I have to
Put it
remember
out
what
there.
one of the chambers has to, maybe the Senate that has to formally adopt it. Yours may just be. Just checking out your rules. So you are directed to adopt a policy against sexual harassment.
okay.
So it is. So in your case, it is really just the panel adopting it and then providing copies and your procedures to the members of the House and the employees, the speaker and the clerk. So yes, when you are done, so are you planning to meet same place, same time next week?
Yes.
Okay, so we will work on cleaning up everything and maybe, and just highlighting anything.
Sooner we get this
Outstanding.
done, the better.
I think so, because also that'll help the Senate, and
Yeah.
I feel like we really need to have this in place before the end of the session.
When?
We need to have this in place before the end of the session. I feel.
Yes,
Oh,
I don't want to drag it out.
Although it will likely need
Well, then you got a whole new biennium.
exactly, will likely need to be readopted by the new panel next Friday.
Right.
But hopefully we'll have something all ready for them to adopt, maybe.
Exactly, yeah. Okay, thank you.
Great.
Thank you, Elaine. Thank you, John.
Thank you.